Okay. So, we're with Emilie Lounsberry of the Philadelphia Inquirer, who is a longtime court reporter for the Inquirer, and wanted to ask you some questions about some of the dealings that you've had with the courts.
Absolutely.
And, making decisions, especially about freedom of information issues. But first of all, let me just get a little background about how you got into journalism and what it was like when you first started off as a woman in journalism.
Well, I started when I was a student at Temple University. I had an opportunity to do some freelance work for the Inquirer, and I absolutely took advantage of that. And then I applied for a job as a part-time reporter for the Daily Intelligencer in Bucks County. And I got that job, and it was my first time in a courtroom, really, and I loved it, and I've been there ever since.
And what time? When was this?
This would have been in the late 1970s.
And how common was it to see women
by that time,
working the beat that
it
you
was
were working?
becoming more common. Perhaps women wouldn't have quite yet been in police beats, but certainly even at the paper in Doylestown, probably half the staff, the reporting staff, was women by that time.
And what was the objection about women covering crime in the courts?
I think it was just before I was really doing police work, I think it would have just been a matter of a woman out at a crime scene with police who would be tending to perhaps use not the greatest language and maybe not wanting to subject women to a particularly bad crime scene or the foul language that might go along or the unpleasantness of police activity. But I think certainly we've obviously evolved from those days, thank goodness.
And one of the high-profile cases you covered was the murder trial of Rabbi Neulander.
Yes.
Can you tell us a little bit about that?
That was an interesting trial, and the rabbi was accused of having hired a hitman to kill his wife Carol. And Carol was found dead on the floor of their home around Halloween, and I can't remember exactly what year it was. It was certainly in the 1990s. I think it might have been 1994. And the investigation at first came up with nothing. There was really not a lot of evidence that was left at the crime scene, and in fact there was suspicion that the rabbi may have been involved, but one of my colleagues at the paper, Nancy Phillips, actually figured out that who the hit person was, and she maintained contact with this person over a number of years. His name is Len Jenoff, and ultimately he confessed his involvement to her, but only on an off-the-record basis. So after a number of months of talking to him and talking to him about how he had this important information, he finally came forward, and based on that information, the case against Rabbi Fred Neulander got much better from the state's point of view.
So she had this information, and she didn't tell the police?
No, because it was off the record, and I'm sure for her it was a very uncomfortable time because she had this information, but she essentially had a contract with Len Jenoff in which she had agreed not to disclose whatever he told her. It was, very much a source-reporter relationship. So she was really in a difficult position until Jenoff did in fact confess his involvement and eventually became a key witness against Fred Neulander. My colleague ended up getting subpoenaed by the defense, and while she had definitely planned on covering the trial, because she in fact became part of the story and had been subpoenaed, she was no longer able to cover it, so my editors asked me to step in and cover the trial, which was one of those great trials, very much a hard-fought case. The state prosecutor was very, very thorough and very good, and the rabbi had a two-person team of really fine defense lawyers. So it was very interesting, and it was so hard-fought, in fact, that it ended up being a hung jury in the first trial. So along the way, from the beginning, the trial judge had issued an order advising the reporters that we were not permitted to disclose the identity of jurors and we were barred from disclosing, we were barred from having any interviews with them, even after the trial was over. So my paper from the very beginning asked the judge to reconsider that ruling. She ultimately held a hearing far down the line, several weeks into jury selection, and declined to reconsider her order. So we tried to, we went to the state appellate division, and they also would not grant us an immediate hearing or even a timely hearing. So we were basically at the point in time when there was a hung jury. There was a lot of speculation about, you know, what was the problem of this jury in convicting this person, and there was just a lot of speculation out there about what was up with this jury. So along the way, as I do in every trial, I was getting the list of the jurors with the intent of ultimately being able to interview them, and I couldn't find the jury foreperson anywhere. I kept looking everywhere in the Camden County, which is where the trial was located. And finally, I called one of our news researchers in our library, and I said, Denise, I'm having trouble finding the address, the phone number, or anything at all for the jury forewoman. And she called me back and she said, Emily, there's a good reason you're not finding her. It's because she's actually residing in Philadelphia, which was a big surprise for me. But ultimately, we were left with the possibility of a story that would report that the foreperson of the jury trial in Camden County of the Rabbi Fred Neulander turned out to be living in Philadelphia. So
that was a problem because? That's
a problem because we wouldn't want to run that story without identifying the foreperson, because especially in this smallish community of Camden County, people knew who the jurors were, even though we weren't identifying them.
But the fact that she lived in Philadelphia, was that a problem?
It could be a possible problem. You're allowed to have dual residency, but under New Jersey law, you're supposed to be a resident of the county in which you are summoned as a juror. So instantly, that became a very possible news story and an important news story for us.
And could that be the basis of an appeal?
That
there was an improper procedure?
It certainly could have been. But you know, we were struggling with how we could pursue this story, because it would be most unfair to report that story without going to this juror and asking, you know, where do you live and under what circumstances are you here in Philadelphia, and that kind of thing. And that's ultimately what we did out of fairness to her. And at the same time, we did want to proceed and find out what the problem was in deliberations that led to a hung jury, and you know, what was it like behind those closed doors. So ultimately, we did publish a story that reported the questions about the residency of the juror, and reported in some measure about the dissent within the jury room, and 4 of us were charged with contempt of court. And it was everyone who...
For violating the order.
For violating the trial judge's order. So we had a contempt hearing. We were found in contempt of court, and ultimately we were sentenced to 180 days in jail that would be suspended, contingent upon us serving 10 days in the Sheriff's Labor Assistance Program, which is the labor detail that frequently, you know, people would see.
Clean up the highway.
Cleaning up the highway, picking up, you know, the streets, that kind of thing. And my paper very vigorously appealed both the underlying court order, even though it was after the trial, we kept appealing that. And we also appealed the contempt findings. And ultimately, the New Jersey Supreme Court said that it was wrong that the trial judge barred us from disclosing any jurors' identification and their names. But they carved out an interesting new area of law, saying that that in death penalty cases, because we're so cautious in capital cases, it's not unreasonable for the trial judge to say that there can be no post-hung jury interviews. So they kind of carved out a new area of the law. Separately, we appealed the contempt findings, and the appellate division ruled in our favor, and so we were vindicated.
Now, what principles led you to make your decision about violating the judge's order?
I've certainly paid a lot of attention to the U.S. Supreme Court rulings that have protected the ability of the news media to gather news, especially in court proceedings. I always bear in mind what Justice William Brennan, who's from here in New Jersey, said in one of the cases, that reporting about the justice system is a core value of the First Amendment, and that those are words that I really keep in mind. And I also certainly knew from going back to the Pentagon Papers case that that in this country it's a high burden on the government to be able to tell a reporter not to report something. And this wasn't a case of national security. I fully believed that this trial judge was just really wrong on the law, but it wasn't a decision that I made on my own. I mean, we talked at length to our editors, and we asked the appellate division to hear us, and I think it's because this type of thing is so unusual that they didn't understand the gravity of the situation. But we were in the position of covering a really high-profile case where there was a lot of unfair speculation, frankly, that was going on about what was quote-unquote wrong with this jury, that they wouldn't convict this person. And I felt very strongly that this was something that the public had a right to know. And I also felt very strongly that there was no way we could write the story about the jury foreperson perhaps being a resident of another state without naming her and without giving her an opportunity to have a comment about it.
And now, when you look at the landscape of the news industry and how many news organizations experience severe cutbacks and more limited resources for investigative reporting and for legal challenges and things like that, do you have any concerns about what that's going to do to citizens' ability to have the kind of information that you were reporting?
Yes. I mean, I would like to say that I would do the very same thing if I were ever in that position again. And I hope that I would, but the expense of defending the contempt case and even fighting the underlying court ruling, it was very, very, very expensive. And my editors, with our lawyers, went all the way to the U.S. Supreme Court at one point in time. And it's very, very expensive to undertake those kinds of appeals. So I do worry that in this day and age where there's a lot of cutbacks in newsrooms everywhere, that we may not have the ability to fight with such ferocity on these legal fronts.
Similarly, nowadays, there are more bloggers being allowed into even federal trials.
Yes.
As you know, I've been in
Yes.
a federal trial. And do you think that they need to be particularly alert
Yes.
to these kinds of challenges? And what advice do you have for them about?
To really study the cases that give us the protections of the First Amendment, and to really do very careful reporting from the courtroom, because it's so much quicker when you're in the courtroom and blogging, or in the courtroom and filing to online. You're moving at a very high rate of speed, and we need to be responsible as journalists and to really be careful and to be fair.
And just ultimately, what happened with Rabbi Neulander?
At the second trial, he was convicted of first-degree murder, and he's now serving life in prison.
Okay. Anything else you want to say on this subject?
Not that I can think of.
Thank you very much.
That was good.